Welcome to the Goal Podcast, news and commentary from Gun Owners Action League, your leading voice for the Massachusetts gun owner.
I'm Jeff. Across the table is Garrett.
What's up, man?
We are days away from the 4th of July.
As we record this, 4th of July is just a couple days away. This will release the day after the 4th. It's going to be a good time, long weekend. You get the whole weekend off?
Yeah, I'm excited. So I think should be working from home tomorrow. Thursday's 4th of July. Friday got off. Saturday, nice. Sunday. And then the following week, I got a little bit of travel for work. And then a little travel over the next month or so.
Back at it.
And then some traveling later in the year.
So you're saying you're doing a little traveling.
Running around.
Running errands all over the states. Cool.
Yeah, no, it's we're as we're recording this, it's Tuesday the 2nd. And we've had a little ongoing discussion about when we're expecting this bill to drop. And I'm expecting it to release either...
Man, don't say that. You're going to jinx it.
The day before, the day after the holiday was my bet for the unofficial...
All right, well,
podcast.
You put it on tape, so if it drops tomorrow before this episode airs, you will have been proven right.
Well, we can just re-record, I guess.
No, I'm sure that, if and when the thing drops, we're going to have a little bit of an analysis period, and then we'll probably get the big guns in to really talk about it.
Absolutely. That is my pessimism of the people that are involved, with the exception of, the couple of, one that's a good guy for sure, but
yeah,
just my pessimism for how the state does things, and it would fit their MO to
it would either be very on brand for them to do something like that, and then
to either ruin a celebration of freedom, or to drop it the day that everybody gets back. Everybody's still in vacation mode. Everybody's just getting back into the office, and then bang, here's the bill. Shove it to the floor. Get it to the governor before 3 o'clock
on Monday. Yeah,
before end of business on Tuesday. So,
oof. Well, I guess we'll see. I hope that you're wrong.
It's a sad state of affairs when you think that's going to happen.
You're wrong too, but it's a possibility. It's a possibility. I'm still holding out hope that they're going to deadlock, but I don't have a lot of faith in that. So, as of this moment, of course, no updates. We're waiting to see what's going to happen. So this this piece, the U.S. Surgeon General, Dr. Vivek Murthy, released an advisory on firearm violence.
Yeah, it's officially now a public health crisis in America. Who didn't see that declaration coming?
Oh, saw that a million miles away. So a partisan appointee of a federal agency decided to use his office to promote something that is politically popular with his cohort.
Of course.
As a public health emergency. What a shock. I'm shocked.
And they've released their justifications, of course, are flimsy at best.
Oh,
reminds me of the My Cousin Vinny scene where he's holding up the playing card. They're going to show it to you just the right way.
There you go, yeah.
But according to the data, which what they're pushing as gospel is just based on some surveys.
Yeah.
They say that 54% of U.S. adults reported that they or a family member have experienced a firearm-related incident in the bunny quotes there, including the use of a firearm for self-defense. They say, of course, they lean on this as the leading cause of death for children and adolescents.
Oh my God, that piece of crap.
Which includes all individuals under the age, or 19 years of age or younger.
Yeah.
So anyone under the age of 20 is lumped all into the same category.
Including all the gangbangers. This is like the classic example of massaging the numbers to get a result that you want.
Of course. And could you articulate the similarities between a 2-year-old and a 17-year-old? Of course not.
Yikes.
Now, later on in their graphics that they released, of course, they said it was consistently highest amongst those age 15 and up, which, of course, we knew that.
Right into what we always knew.
But now they're leaning on, God, I wish I could have the visual of putting the bunny quotes around this. Those who experience collective trauma and fear is now all encompassed in this thing. It's a collective fear response.
What does that even mean?
Well, it means that they're using propaganda to scare you, and now that we can count all of those people as those that have been affected by firearms incidents.
Right. So people who people, wait a minute. So people who have been stirred up to be afraid of guns, those are now part of the statistic that have experienced gun-related trauma?
Essentially, yes.
My God.
But the poll that they used, and I had to dig through this, the poll that they used was a paid poll conducted with about 1,200 respondents by this group called KFF, who does poll tracking.
Out of 300 and something million, that's it's a good sample.
Certainly. I mean, that's smaller than the size of people that were surveyed for defensive gun use, but neither here nor there. But
yeah, the one that they said was not a representative sample.
Of course.
Yeah.
But this group tracks things like public opinion on the Affordable Care Act. If you go through their stuff, you can tell that there's a certain leaning.
So wait, the way how did you put it before? They pulled the checkout line at Whole Foods.
Yeah, you can prove a poll as long as you select the perfect group. But no, they send these polls out via spam email and phone calls, which for the regular people, you either filter it to junk or you don't answer that phone call.
Right. Unless you have a political axe to grind and you want to get into it.
But they ask questions like, have you or anyone you're related to ever been threatened with a firearm or witnessed someone threatened with a firearm, been injured by or witnessed someone who's been injured by a firearm or used a firearm in self-defense?
Wow.
So not even if you've seen it happen, that you've just witnessed someone, someone who has been at some point in their life.
Somebody happened to something else, to somebody else.
But they said about 1/3 of adults surveyed said that they have avoided large crowds, such as music festivals or crowded locations, to help protect from the possibility of gun violence.
Yeah. Okay.
Which,
that's your fear does not constitute fact, right?
True.
The fact that you're afraid of something happening does not mean that it's that it's actually in danger of happening. I mean, I say the same things with all like the panic rooms that people want to install in kindergartens and things like that. It's just because you have been programmed to believe that something is common and dangerous and traumatic and all that stuff doesn't mean that that's the reality.
the generation that preceded me was the duck and cover nuclear alert drills.
Yes, exactly.
We did stop, drop, and roll in case you catch on fire.
Yeah.
And this is the new iteration of we have to do something to keep people
Exactly so.
I don't think that avoiding large crowds is that big of a problem, though, because that's something that you do, I do.
Oh, sure.
And mainly we do it because they don't have adequate security, and then they enforce rules where you're not allowed to protect yourself.
Right.
So, yeah, I'm not going to the place where I'm forced to be a defenseless victim to someone that isn't going to follow that rule anyway.
So the thing may have this kernel of truth. I mean, you're absolutely right, but at the same time, the conclusion drawn by that is totally wrong.
It's like, do you avoid dangerous neighborhoods? Yeah, of course I do.
Oh, therefore you're afraid
you're
of gun
affected.
violence.
But they said more than 8 out of 10 adults they surveyed have taken some precaution to protect against firearms violence, such as talking to your child or family members about firearm safety. That is part of what they're using to justify this. If you've purchased any other means of self-defense, tools like pepper spray, if you've purchased a stun gun or any electronic sort of thing, if you've taken any self-defense classes, they're lumping that in with this generalized response to firearms.
Violence, fear of firearm violence.
If you've taken a firearm safety course. And then there's a bunch of things
we
that
give safety courses. What does that make us?
And then a bunch of things that just amount to increasing your situational awareness. But they said 3/4 of households with firearms say that their firearms are stored either, and this is like an either or thing, in the same general location as ammunition, or in an unlocked location, or loaded.
Okay, so if your gun is loaded, it is also in the same general location as ammunition. And what does the general location mean anyway? My gun safe is there, my ammo is there.
It doesn't specify whether they mean in the same locked container, if it's in the same room.
Yikes.
They just say if it's in the same general location as ammunition, or it's in an unlocked location, or if it's loaded. So they don't say...
Believable.
So this encompasses essentially every method of storage you could possibly come up with.
Yeah. So there you go. 3/4 of the household, 3/4 of households. And this is their part of their rationale for calling this a health emergency.
Oh, yeah. And they have other rather notable like face palm moments. So they say that social capital, which is the level of trust in institutions, social mobility, income inequality, and social service spending all correlate with this firearms violence.
Ooh,
so imagine that as you undermine the collective trust in institutions, firearms violence goes up. Imagine that.
Imagine.
Wonder who's pushing that sort of propaganda. And then as upward mobility is cut off, you know, and you can read into that, like, I don't know, due to inflation and stagnated economic conditions, firearms violence goes up.
No kidding.
Imagine that, and imagine where that is more predominant. But they're openly taking the anti-smoking, the anti-tobacco model, and just really applying it to firearms.
Oh,
so they're going after and propagandizing it towards children.
Yep.
Because again, they're counting in, if you've talked to your family about firearms safety, that is part of the problem.
You're a victim.
And you're counting in these statistics.
So what do we do about it, in the Surgeon General's opinion?
Well, their solutions are give us more money.
Naturally.
So, as they put it, increased funding for surveys and research, which you're definitely not biased, of course.
Oh, totally no. No, totally.
But their policy suggestions, this is the policy suggestions, safe storage and child access prevention laws, universal background checks and purchaser licensing laws, including enhancing minimum purchasing ages, mandatory training requirements, and built-in waiting periods. So, I mean, this whole thing is written by Giffords, I'm sure.
Oh, yeah.
Effective firearm removal policies like red flag laws and domestic violence prevention orders. Assault weapon and large capacity magazine bans.
Naturally.
Restrictions on open and concealed carry, the sensitive places situation. Huh. They want to dismantle and remove the PLCAA, Protection of Lawful Commerce and Arms Act, by saying that they're going to treat firearms like other consumer products.
It is treated like other consumer products. PLCAA just prevents people from going further.
And there's a court case we're going to talk about later where there is a company that's being held to task for the products they...
Stay tuned.
Then they tacitly hint at smart gun technology, but providing a continuum of trauma-informed mental health care. Again, pushing the idea that you're a victim, you've been traumatized,
and you need mother government to come and tell you how to live.
But it's largely a cheerleading section for the Bipartisan Safer Communities Act that was pushed out, and saying that our failure...
This is a freaking laundry list of Giffords' talking points and Joe Biden's talking points.
Yeah, it's the same gun control agenda. They just now have installed someone in a position of titled authority and declared it a public health crisis because...
They didn't even like change the words or the order. They just, they regurgitated the same list.
Same stuff over and over again. As we've seen over the last handful of years, the guise of a public health emergency can be used to do all sorts of things.
Mm-hmm. Oh, yeah. Declare something an emergency and see what you can get away with.
The Supreme Court has been dealing with it, I think, rather well, reinforcing that the Second Amendment is a constitutionally protected civil right.
Yeah.
It doesn't need to be going anywhere. And again, if someone is choosing to act irresponsibly and should no longer be able to access their rights, why should they have access to you, to me, to everything else in public?
What a novel idea. Well, so that guy deserves about as much attention as we've given him here. The guy, he's a windbag. He's one of, he's an appointed federal apparatchik that's going to toe the party line and, all that stuff. And
he was handed a thing, said, here, read this. And then that way somebody else can go out and say, well, the U.S. Surgeon General
says it's a public health emergency. We must act. Somebody think of the children. Wait to see what happens. And certainly something's going to try to come of it. Anyway, as we record this, the Supreme Court actually wrapped up their term yesterday and they recessed for the summer. Before they did, however, they sent out a whole bunch of 2A related cases. Now, we're going to talk about a couple of things in particular later on, but they disposed of a bunch of cases that were pending before the court. So, for example, the Illinois assault weapons challenge was denied certiorari.
That was the one that I think a couple of them said that they wanted to hear that one, but it ultimately didn't get the majority vote. You
need 4 votes in order to grant cert. Justice Clarence Thomas and Sam Alito both said that they would have granted cert in the case. Justice Thomas, my man Clarence Thomas, issued a statement along with the denial of cert, criticizing the Seventh Circuit, that's Illinois, and saying that the rationale for upholding the Illinois law was, quote, contrived and nonsensical. I do have to read this. This is a quote from his dissent. This court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedents provide, the Seventh Circuit concluded that the Second Amendment does not protect, quote, militaristic weapons. It then tautologically defined militaristic weapons as those, quote, that may be reserved for military use. So they're trying to wind it all the way back to, to Miller. He also said that, quote, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. There it is again.
Common, which was
in common use.
Which was in the dissent for the bump stock case.
Cargill v. Garland. It goes all the way back to Heller. He did, and I picked this part out, he does seem to anticipate that this is not the last that we're going to hear of this from the Second Circuit, because he preemptively said, but if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the cases reach a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right.
To me, I don't understand how anybody could argue that. However, under the recent ruling, so post-Bruin, post-Cargill v. Garland, it really shouldn't have to go back up to the U.S. Supreme Court to cover this topic.
Yeah.
Between McDonald, Heller, Bruin, Cargill, you can't just make stuff up and arbitrarily ban. These aren't banned. They're banned. They're unbanned. They're banned. They're unbanned.
No, you're
okay. It's not okay.
Right. And I think what he's tacitly saying here is that, yes, we all know that the Seventh Circuit is just going to rubber stamp their political priors. But when it gets back up to us, I'm saying now that we should, attack it.
Sadly, I think this is the kind of thing the Seventh Circuit is going to rely upon in allowing such a ban.
Yeah, they're going to say,
because the lower courts say, well, hey, if the Supreme Court overrules it, they overrule it, but I don't want my name on the decision that says that ban has to go.
Yeah, we'll just kick the can instead of
it's
doing the right thing.
Political decision for those justices to say, it's like referees that rely on instant replay. Well, the instant replay will catch it or the coach can challenge it. So now I don't need to pay attention to the play anymore.
I can just rest safe on my political priors and somebody else will take care of it. It's pretty disgusting.
But
bunch of other cases were disposed by GVR, grant, vacate, and remand, which we know is a term that's used by a Supreme Court in sending cases back to the lower courts to be reheard in light of some other decision that the Supreme Court did, right? So they're saying, okay, we accept it. We're going to vacate your decision and send it back to you because of something else we recently did. We want you to look at it again.
Yeah.
So many cases were GVR'd in light of Rahimi, which we're going to get into a little bit detailed a little bit later on. So among the cases that were GVR'd back down to appellate courts, there were a few felon in possession cases. One is Garland v. Range. Some of these names will sound familiar. Vincent v. Garland, which was a non-violent felony. That was for check writing or something 10 or 12 years ago. So she ended up being prohibited for doing that. Let's see, there's Doss v. U.S., Cunningham v. U.S., Jackson v. U.S., all of those felon in possession cases were GVR'd back down to lower court. Possession by users of controlled substances. That one's U.S. v. Daniels. That one's also a familiar name. Another one is U.S. v. Perez Gala, I think. But that's regarding possession of a gun by a subject of a restraining order. Again, sounds familiar, right?
Yep.
Under Rahimi. And this one, Antoniuk versus James. This one goes back to New York's concealed carry law, which requires citizens to prove, quote, good moral character in order to possess a light.
The suitability.
Look at this. Yeah. And it's didn't we just handle this 2 years ago in Bruin? This is the kind of stuff that we talk about, what Jim talks about when he's here going, Bruin didn't settle anything. All it did was, shape the conversation. Bruin didn't win anything. That's not how this works.
Yeah.
Because the people that are fighting it are still going to fight it regardless.
Oh, absolutely. It's this constant battle back and forth between, and they really don't want to give up on their position.
No, of course not. Well, that goes to them arguing this other stupidity, another aspect of the Antoniuk case, which a lot of people don't talk about. The other thing that they're trying to clarify is whether the historical period for ascertaining the meaning of the 2A, right? We go text, history, and tradition. If that period starts in 1791 when the Second Amendment was ratified, or in 1868 when the 14th Amendment was ratified to incorporate the Constitution against the states.
Which is just such a petty argument.
Isn't that a stupid friggin' argument? You know, the state is actually going, no, it doesn't apply because the 14th Amendment, you know, so that's the period of time we have to deal with. It's ridiculous. It's ridiculous. That's exactly.
It's such a childish level of argument, in my opinion, too. Essentially, what they're saying is they still want to retain the ability to arbitrarily and subjectively deny licenses to anyone they don't like.
Yeah.
Which, broadly speaking, is the public.
Yeah.
Those in power do not like those that they see below them to have any meaningful avenue of recourse.
That's what a ridiculous argument. Anyway, so Supreme Court, they're heading back to wherever it is they head to when they're not in court. We will see what's coming down the pipe in the next term.
They have had some big decisions in the last couple weeks.
Yes, they have.
Very big.
Yes,
so we had Cargill v. Garland,
yep,
where they took a stance on the bump stock issue.
Yep.
Then they decided on US v. Rahimi, which we were watching, to see how that would come out.
Yeah. Yeah, we talked about this one months ago.
We've been following this, and I think this is a great example, an exemplar of the reality of our legal system and why the mentality of, you know, put bunny quotes around this, just file a lawsuit, is not always the most strategic answer for every situation.
That's right. If you just throw a lawsuit out there, you have to be prepared for the possibility that it will be accepted and not be a good case to argue your side.
It's like you told your boss, "Give me a raise or I quit," and they go, "See you later."
See ya.
Oh no.
Yeah, I was like, oh no, that's not how I thought this was going to come out.
This ended up in an 8-1 decision. So this wasn't even split along ideological or what we would consider typical ideological lines. 8-1 decision. All of the justices except for Thomas. Thomas was the lone dissenting opinion in this whole thing, which to me might just mean that he.
Well, I found his convictions in his dissenting statement. I found his convictions strong. He made a lot. Well, we'll get into it. He made a lot of arguments about surety bonds and things like that. But
he made a very principled argument.
Yes,
but
he did.
One could argue that he's taking that position because he wants to get certain things into the record.
You could argue that. Sure.
The decision essentially said when an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment.
That's the holding.
That's the holding.
Summary holding. Now, this guy Rahimi was not a good plaintiff, really. I mean,
he was not a sympathetic plaintiff.
That's what I was looking for. He was not a sympathetic plaintiff. He's not the guy that you want representing your cause.
Yes. Multiple and rather credible allegations of domestic abuse. Multiple and credible allegations of discharging a firearm in public by means to intimidate other people, like for rather unscrupulous reasons. We'll put it that way.
Yeah, when we dedicated an episode to this, or when we, back when we talked about this before, I was pretty clear that I did not like the way this was going. I didn't think this guy is a sympathetic guy. I didn't think this was really going to go our way, and.
Yeah, this was one where I think the point was going to override the principle.
Yeah, that's a good way to put it.
But there were consistencies and inconsistencies with Bruin. It did not remove the text, history, and tradition standard.
Yep.
But they do expressly say that an identical historical twin is not necessary, and an acceptable historical analog may still be enough to pass constitutional muster.
That's another thing I was afraid of, is that they were going to use Rahimi as an excuse to start backpedaling Bruin.
This was, I think, a conclusion that they were going to reach sooner or later, to say that you don't have to have a verbatim exemplar from some point in history, wherever that may be.
Yeah.
To make an argument for what's going to happen in the future. Was the point I think that they were going to get at. But Rahimi challenged this law, and this was described by Chief Justice Roberts and Gorsuch. He challenged the law on its face, and they said that this was the most difficult challenge to mount successfully because it requires the defendant to establish that no set of circumstances exists under which this law could be applied in a constitutional manner.
Right. Yeah, a facial challenge is pretty much the hardest way that you can argue this kind of a thing.
So very difficult to say that absolutely no circumstance exists where this would not be a constitutional violation. So that's why, in their conclusion, they wrote, found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed.
Yeah. So the right is not gone. The right is. So I think they advisedly used the term temporarily in order to, I think they used this phrasing carefully because it impacts other potential cases, right? Those like felons in possession and so forth. Those are permanent disarmaments.
Yeah. Now, potential positives of this outcome is because of the way, like you said, they worded it.
Very narrow.
They were rather consistent in leaning on the temporary nature of the deprivation of rights under these circumstances.
Yes.
And refers to the fact that the law only prohibits firearms possessions only for the duration of said restraining order.
Yeah, right. So it's not a permanent ban. It's not until we feel like giving you your rights back. It's like if this person's a threat and the restraining order says that they're a threat for this period of time, then that's how long.
Yes, because in some states, the loss of those rights extend beyond the ending of the restraining order. So this language might actually help remedy some of those situations. I think California is an example of that, where if you've ever had that domestic violence restraining order against you, that is a much longer deprivation of rights beyond that circumstance. And the court also rejected the government's contention that Rahimi could be disarmed because he was not, and funny quotes around this, responsible. And the majority opinion said that the term responsible was too vague and unclear of what such a rule would entail of what constitutes a responsible person outside the scope of like an actual criminal conviction. So that may make it easier to challenge things like suitability on a vagueness standard, saying it's just too vague to.
I'll buy that. Yeah, okay.
So those are potential positives. That's looking at it with the rose-colored glasses.
Yes, right. The optimist view.
Now, from the pessimistic side, Justice Jackson just...
Listen,
when you're in a hole, digging deeper,
that woman is universally bad. Every single thing that I've written from her, both, now that she's on the Supreme Court and the stuff that I've read from back before she was on the Supreme Court, she is, to my mind, like the worst justice as far as, individual liberties and personal rights that I think I've ever read.
It's certainly going to be a long-term issue.
Yeah, she's terrible. She's universally terrible on these kinds of issues.
Her consistent opinion is that the Constitution's unfair to the government's authority.
She said that the last 3 decisions in a row, she said that, in so many words. It's like, this is, how dare we limit the government's
and she goes right. Power. She goes right after Bruin, saying that, and this is from her
directly. And this is another thing that itches me out because she's like, instead of arguing the merits of this case, she takes the opportunity to crap on the case from 2 years ago.
Yeah, she said, it isn't just that Bruin's history and tradition test is burdensome. The more worrisome concern is that lower courts appear to be diverging in both approach and outcome as they struggle to conduct the inquiry Bruin requires. And it's like, because some courts are desperately trying to circumvent the Bruin ruling.
They're trying to,
and it's only
a round peg in a square hole.
Certain courts in certain districts that seem to be struggling with this.
Yeah, right. Isn't it weird that those seem magically to line up with those who ideologically are set against the Second Amendment?
And truthfully, I think her writing's just poor. Which I'm hoping it just gets better for the sake of clarity.
I hope so. I mean, they have clerks that actually write these things, don't they?
But especially continuing to go after Bruin, she's asking, who's protected by the Second Amendment from a historical perspective? To what conduct does the Second Amendment's plain test applies? What historical eras should we look at? So she's asking all the questions that they answered in Bruin. And she goes, how much support can non-statutory sources lend? I can go on, as others have, but I won't.
Oh, but I won't.
It's like this.
What kind of a legal, right.
This isn't a Facebook post.
It's gross. Sophomoric.
But she says maybe courts, including ours, will find a way to bring discipline to the increasingly erratic and unprincipled body of law that is emerging from Bruin.
Yeah, the easy way to do it is to strike it all down. It's a fundamental right. Well, anyway,
so but Thomas wrote a pretty principled dissent.
Mm-hmm.
And he said, essentially just as important as the law's express terms is it's not only what it says, it's what it doesn't say. So he's saying that it does not require that a person has ever been committed.
Has ever committed. Yeah.
It does not require that a person has ever committed a crime of domestic violence. It is not triggered by a criminal conviction or a person's criminal history, and does not distinguish contested orders from joint orders. So it strips an individual of his ability to possess firearms and ammunition without any due process. Rather, the ban is, as he put it, automatic, uncontestable consequence of certain orders.
That's a strong argument in my mind, because it makes the argument of due process. Now, people will argue that due process is not always, indictment, trial, conviction, etc. That people will say that, that hearing before a judge also constitutes due process. So he's still getting his day in court. But for many of the situations, these things happen like behind closed doors without people getting the ability to, defend themselves or face their accusers or any of that stuff. It doesn't necessarily have to be a trial, but for God's sake, if you're going to have your constitutional rights taken away, it should be more than, a cop or a public lawyer and a judge in a room just signing off pieces of paper.
We see very similar time frame patterns with the red flag bills. So essentially, someone files the paperwork for the restraining order for the red flag or whatever it is. If that gets granted at that time, you get served your papers. They'll say you're the subject of it. You get served your papers, and they confiscate your firearms then.
Yeah, yeah.
And then you have to go to the court for the hearing to justify whether or not you can get those firearms back. So
you got to go beg the court to have them back.
So what
judge wants to sit up there and go, "Oh no, I gave that guy his guns back,"
and then have something happen.
Yeah, right.
So
then something happens.
There is a deprivation of rights prior to anything that I think could be construed as a due process of law. What I think Thomas leans on is that if you're going to, when we talk about due process of law, if you are going to lawfully restrict someone's civil rights, someone's constitutional rights, the standard for that has to be higher than the evidentiary standards that are used for proceeding like a restraining order, whether it's an ERPO, whether it's a domestic violence restraining order,
et cetera, et cetera. Yeah.
Exactly. So that the burdens of proof, the standards are much different. They're much lower for a court setting like that. So I think that's what Thomas is leaning on, saying that, hey, under any other court circumstances, your burden of proof is higher to take someone's rights away. This should not be an entity unto itself where your rights are subject to a lower standard just for this particular proceeding. So I think that's kind of what he's going for.
Well, I mean, so we both held the position that this was probably not going to go. I mean, the Supreme Court was never going to say, no, you can't take guns away from people who are documented threats to society. That they were never going to find that way. Rahimi was not a sympathetic plaintiff. The case was not argued well back when the oral arguments happened. We were all saying, me, you, Mike, we were all saying that this guy was not arguing well in front of the court. He's like a federal public defender or something, right? I mean, not to impugn his credentials, but this is a different forum.
It's really tough if going into it, nobody likes your client.
Yeah, right.
Like there was nobody outside saying, free Rahimi.
Free Rahimi.
So it was, and that's where you have to take that step back and realize that it's much less a justice system as it is a legal system.
Yeah.
So the idea of fairness and the blind lady justice with the scales that are not influenced by any other factor other than these black or white situations. It's not how it works.
Well, so the case was never going to be a good one. But I feel like in phrasing the opinion of the court the way that they did, even though, people like Jackson, of course, had to write her own concurrence so that she could, crap on the court from before she was there. The actual decision was written carefully, I think, and it was narrow. So there's actually some not so bad points that come out of it.
Roberts penned the decision, and I've kind of grown to appreciate his perspective. I mean, he's always been kind of the fence sitter.
Yeah, he's not
kind of going back and forth where,
He's not ideologically 2A like I kind of wish he was, but I respect his positions.
But I'm much happier seeing that he wrote this decision as opposed to
somebody like a Sotomayor.
Yeah, I mean it was an 8-1 decision.
Horrible. Yeah,
that could have been written by anybody he delegated it to.
Yeah. In another Supreme Court case, this one is not directly related to the Second Amendment.
Well, but it is.
It is, in a manner of speaking. This, after 40 years, the Supreme Court has ended the concept of Chevron deference,
which
has overturned it.
Which it wasn't a giant pull the rug out from under the whole philosophy. Chevron deference has been significantly pared back from when it first came into effect back in
84,
back in the 80s.
Yep, 1984.
It's going to make you feel old to say that I wasn't alive in 84.
Oh, my goodness gracious. I just sprouted another gray hair, and then it fell out.
But this case, Loper Bright Enterprises and others v. Raimondo.
Yay, Gina Raimondo. Gina. Makes me happy.
Rhode Island's finest.
That's right.
I'm glad her name is attached to this decision on a personal level. But her in her position as Secretary of Commerce.
Yeah.
So this is a 6-3 decision, of course.
Of course.
This one split certainly on more, I would say, ideological lines of the constitutionalists versus the interpretive, let's grab power group.
The outcome-based ideologues, you mean? Yeah.
So this is another opinion that was authored by Chief Justice Roberts. He was joined by Thomas Alito, Gorsuch, Kavanaugh, and Barrett. Dissent was filed by Justice Kagan, who was joined by Sotomayor and Jackson. Whether Chevron USA v. Natural Resource Defense Council, Inc., so this is the original Chevron case in the 80s, should be overruled or clarified. Under the Chevron doctrine, courts have sometimes been required to defer to permissible agency interpretations of the statutes those agencies administer, even when a reviewing court reads the statute differently. So, this is so much more in your wheelhouse than mine.
No.
But if you could give an explanation of what Chevron deference is and what it has done in its effect.
So as like a libertarian, right? This is why I live with Chevron, is because it's an administrative agencies thing. So third grade social studies. Under our system of government, we have 3 co-equal branches of government, right? Executive, legislative, judicial. They're supposed to be separate, and they're supposed to act as checks and balances on one another. The legislature makes the laws. That's Congress. Executive branch under the president carries them out via administrative agencies: FBI, ATF, EPA, SEC, FCC,
all the little agencies.
Exactly. The judicial branch's job is to evaluate laws, and it also resolves any conflicts in law and in interpretation of the laws. Courts, all the way from the state level, district, all the way up to the Supreme Court. That's the judicial branch.
They're supposed to be the referees. Keep it fair.
Precisely. So Chevron deference was this principle set down in the Supreme Court in 1984. The case was Chevron versus National Resources Defense Council, NRDC.
Yes.
Yeah. So essentially it said that if there's an argument about what a law means, so Congress passes a law and there's an argument in court about what that law actually says because there's some kind of a gray area that Congress didn't address, the federal judge in the case has to, by policy, has to defer to the agency that's in charge of administering that law. So what does that mean? That means that, judge, whatever his personal feelings are, he has to take the default position that the agency knows best. The reasoning goes that since the agency is the so-called, expert on the subject matter, they would know better what Congress meant than anybody in the court would. Okay, that's the rationale. For a salient example, let's take a look at bump stocks. Congress passes a law saying that machine guns are regulated, subject to the NFA, right? Et cetera, et cetera. We've been talking about this for years. They leave ATF in charge of enforcing that law. ATF checks the political winds, right? They go, stick their finger in the air and they go, oh, well, what about bump stocks? Bump stocks, increase rate of fire of semi-automatic rifles. Therefore, they are machine guns. Even though Congress didn't say anything about bump stocks in the law, we think that they must be machine guns too. And so now anybody who has one is subject to the NFA and can be thrown in prison for violating the NFA. So what happens? Case goes before a judge. Under Chevron, the judge in the case would be required or would be supposed to say, well, the ATF are the experts in the subject matter. They are the gun people, after all. They know what Congress really meant to say. Chevron deference says that I have to assume that the ATF is right, and I have to rule accordingly.
So essentially it puts the
default position in the court of the government.
So essentially, instead of saying that you're innocent until proven guilty, it is you are what the government says you are
until you can show otherwise. Right. Until you convince everybody otherwise.
They get to interpret things as they see fit.
They get home court advantage by policy.
That's a good way of putting it. Home court advantage. It's not supposed to be that way.
It's not supposed to be that way. The same thing is true outside the gun world, right? We're naturally gun people, but EPA, FDA, FCC, pick your alphabet soup agency. The same thing applies. The potential effect on the average American is huge when you take all this into consideration. It's everything from licensing to how you use your farmland, drug policy, what you can do with your personal property. It's huge. These federal agencies just have the power to say, no, well, we actually know better what Congress meant. So, the ball is in our court. So people that support this idea of Chevron deference, who coincidentally, now it's my bunny quotes, coincidentally tend to be supporters of powerful centralized government. They say that Chevron makes sure that federal regulators have the power they need to enforce Congress's laws without being overruled by so-called activist judges, or, to use a phrase of our newest Supreme Court justice, that federal regulators' power is not being hamstrung by that inconvenient thing such as the Constitution. For me, the problem that I have with Chevron is that it concentrates way too much power in the administrative agencies. It takes away the ideal of unbiased fairness from the courts. The Constitution says that judges, not unelected bureaucrats, are supposed to be the arbiters in these things, right? They are the ones with the power to interpret law. And that makes sense, right? You don't give the power to decide what a law means to the same people in charge of throwing you in jail for violating it. That's That's an unfair concentration of power.
And I think it certainly creates a conflict of interest when an agency can develop its own scope of work.
Absolutely.
And therefore justify, have you seen a public agency get smaller ever?
Ever.
So,
yeah, we don't need quite that much money this year. We'd like our budget to go down.
And just like we kind of casually mentioned, it takes the responsibility off the legislature to actually do anything meaningful.
Yes,
because they can write some kind of arbitrary, vague. It could go either way. Therefore, nobody's really mad at me, and I can win my popularity contest.
And they kick it over to the
administrative state says, well, I can justify pretty much whatever I want, which means I can justify whatever budget I want, which means I now get to take more of the pie.
Exactly.
And then you wonder how it's like, how did that agency misplace almost $10 billion last year and nobody got fired?
Nobody got fired. The bottom line here is judges are supposed to be the umpires, right? Impartial. They call the balls and the strikes. Under Chevron, they had to leave that behind. And, to mix metaphors, they were forced to put a thumb on the scale in favor of the government. That's like the bottom line of what Chevron did. And now, thankfully, gladly, that's overturned.
And as much as the people are saying that this is the court usurping power for itself,
it's absolutely not true.
It's the exact opposite. That power was essentially given away by the legislature to the executive, which it can't do per the Constitution.
Yeah. The Constitution says Congress makes the laws.
And there's, I think, a rather wild sense of irony that people are saying that the courts are somehow
it's power grab on
are radicalized in saying that, no, like this is supposed to be balanced and fair. And we're not supposed to see these wild, radical policy shifts every 4 years.
Right.
Where all of a sudden it's like,
this is legal. Tomorrow it's not legal. Today, you're fine. Tomorrow. Yeah, it's right. This puts pressure. This is what people are so upset about, is the fact that this puts pressure back on the legislature to say, if you're going to restrict people's rights, you better goddamn think about it and write a conscientious, enforceable, proper law.
Not just that, but that's your job. You have to do your job.
That's literally what you get paid to do. is yeah. Anyway, you get pretty hot about it.
Yep, but SCOTUS lead, so they held that, so there was this Administrative Procedures Act that predated Chevron.
1946.
And that required
1946.
That required courts to exercise their independent judgment in deciding whether an agency had acted within its statutory authority as given to them by the Congress. And that the courts could not just, defer to an agency interpretation simply because, well, the statute didn't expressly say one way or the other.
Yeah.
So it says the courts need not and the APA may not defer to an agency interpretation of the law simply because the statute is ambiguous, and they held, therefore, Chevron is overruled. So that
Total sense to me. Yep.
That Administrative Procedures Act was supposed to be a check on the administrative state, whose, like we said, their zeal,
their ideological
might have otherwise pushed them to excesses not contemplated in the legislation that actually created the administrative state to begin with. Notable dissenting arguments. So this is authored by Kagan.
Well, so the Roberts' statement was that Chevron basically runs afoul of the Administrative Procedures Act, right?
Yes,
they cannot exist. They can't
coexist peacefully.
Exactly. So some dissent from our friends on the
from the people who want
the power to be unhamstrung, or what's the opposite of anyway.
Well, these are the people that believe the government has rights, not authorities.
Yeah,
that the government has the right to do whatever they get to create their own rights that supersede yours. But Kagan essentially argues right off the top that the court, the judiciary, has usurped power from the executive branch by saying that the executive's authorities are limited to executing the laws as written by Congress.
Which is exactly what it says in the Constitution.
Civics 101.
That's exactly what they're supposed to be.
I would point out to you that, there was a time when that class was called civics, and then it changed to social studies.
That's right.
And that's when they stopped teaching about how the government was supposed to really work.
Yeah, right. I'm just a bill.
But she also leaned on a concept called stare decisis. Decisis? Decisis? Stare decisis. And that's a legal principle of determining points in litigation according to precedent.
Right.
So according to Kagan, essentially, it's like...
When they say things like it's settled law, that's kind of what they're talking about.
Yeah, she's saying, well, since this has been the way it's been for the last 40 years, it's a way to remind judges that wisdom often lies in what the prior judges have done.
What? She's that conservative?
And that Chevron is an entrenched precedent entitled to the protection of stare decisis. So she argued that since the regulatory agencies that have enjoyed this outsized amount of power, says, well, since those are ultimately answered to the executive, like the president, and the president's elected by the people, that means that there's a sufficient amount of accountability in the bureaucratic state, in the administrative state. So that's all fine.
Nonsense. It's funny that she doesn't rule so conservatively when it comes to like gun cases or,
Well, and you can look across history at cases that have been overturned that existed for plenty of years.
Yeah, where stare decisis has been overturned.
Yeah, like, I don't know, Dred Scott v. Sanford. Now, that case ruled that slaves, including free slaves, were not allowed to be U.S. citizens.
Yeah.
Now, that was ultimately eliminated by the 13th and 14th Amendments, but...
You're respecting stare decisis, but...
That was the law of the land for a very long time.
Yeah.
That eventually got overturned. Same for Plessy v. Ferguson. That was a decision where they ruled that was the whole separate but equal. Facilities that were segregated by race were constitutional as long as they were considered, quote-unquote, equal, which ultimately got overturned. I wonder what her position of precedent would be on that case.
Yeah, would have been on that one, sure.
And then, Goodridge v. Department of Public Health, Obergefell v. Hodges, those all overturned long-standing precedent, and I don't think she would argue that those cases should have stuck on precedent. So
yeah, so she's cherry-picking.
Very much cherry-picking, and that's the problem with unprincipled arguments, is that unprincipled arguments only work for your point.
Yeah, right.
Where principled arguments you can apply across the board. Even when it's not at its most convenient for you. But no, I think Chevron deference to me is a perfect example of the phrase, the path to hell is paved with good intentions. So if a regulatory agency was truly benign in its approach, Chevron works. Like if they had the discipline to restrain themselves, it would work.
Right. In a perfect world.
But the founding fathers, in all their wisdom, when they were writing the Constitution, knew that giving that much effective power to an unelected oligarchy
Pretty much
inevitably led to tyranny. So saying that the court was not allowed to have its own opinion on something that was legally ambiguous and has to defer to the government saying we get to do whatever we want, it undermines the entire foundation of the Constitution.
Yeah, the separation of powers.
And
yeah,
as we've seen over the last decade or so, and even longer, these agencies have kind of divested themselves from impartial and objective expertise in favor of political partisanship and malfeasance.
Exactly.
So, are these really experts anymore, or are they
they're
political
activist
figures
wings of the executive branch,
like the U.S. Surgeon General using a survey of 1,200 people to declare a state of public health emergency over
the ATF
over fire.
Changing positions based on the winds.
The IRS targeting groups based on political affiliation, the Department of Justice being weaponized against the people, collusion of censorship that was highlighted in the Twitter files.
Yeah.
The ATF's practice of redefining laws to mean whatever the heck they want them to mean, even in direct opposition to what they've also said. It's not to say that the status quo can't be challenged or altered, but challenging or any challenge or alteration can and should only serve to expand the rights of the people or limit the authority of the government. Either one works for me.
That's right. They're both in the right direction.
But again, what these court decisions are outlining, it's saying that the court can use their own brain. It's not forced to take the position of the authority over the people. It's all saying that the courts can make a decision on their own. They have the expertise in interpreting law. That is their expertise. And saying that their expertise is not worth what some person from OSHA decides.
Exactly.
It's ridiculous on its face.
I agree with you wholeheartedly. Okay. I think Chevron was terrible legal doctrine. I'm thrilled to see it go. In limiting the power of the administrative state, there's a couple of other cases that were recently decided just last week that kind of fall in line with this. So SEC versus JARCSI, the Supreme Court, JARCSI, I'm not sure. The Supreme Court held that the Securities and Exchange Commission has to hold civil fraud suits in federal court instead of forcing people to navigate the SEC's internal administrative law courts. Right? If you're going to force somebody to go through a civil lawsuit, you got to do it in court instead of, an administrative,
because that was part of Chevron.
Yes.
Is like EPA can say, we decide what the violations are. We charge you with it. We determine whether you're guilty or not. Then we levy the fines against you.
Right. I mean, what could be more wrong than making a single federal agency the investigator, the prosecutor, and the judge? Okay. Also, there's another one in Corner Post versus the board of directors or the board or whatever it is of the Federal Reserve. Limitations on claims of injury. You're going to love this one. Limitations on claims of injury from a federal agency accrues from the date of the injury and not the date of the original rule, as the agency has asserted. Parse that out. The person says, you have this regulation. I am injured by it. Therefore, I'm going to sue you. The agency comes back and says, well, the statute of limitations or whatever for filing claims against that is 6 years. We passed that rule more than 6 years ago. Therefore, you have no standing to sue.
So if I hit you with my truck, you can't sue me for hitting you with the truck because I bought the truck before such a thing existed.
We passed
before the statute of limitations.
Just because you were injured recently doesn't matter because we passed that rule. Isn't that ridiculous?
It's just the fox watching the hen house, and this is the stuff that.
So this removes the power of the agency to basically just run out the clock, right? So they pass a rule, they run out the clock, and then going forward, once that clock has run out, they can just say, "Nope, sorry."
Yeah, you mean like
you have no standing.
A certain former attorney general, now governor, changing the rules in 2016 about what was legal and not legal to purchase and own and possess, and saying, "Well, we're not gonna We're not going to jam anybody up over that. We promise.
So taken all together, right? These three cases, these are all good rulings to my mind. But in keeping with the context of this podcast, I have to say I'm a little bit reserved when it comes to what I think the impact of Chevron is going to be on gun cases specifically. I've seen a couple of, YouTubes and so forth saying that this is the end. This is, once again, this is the greatest thing ever. And calm down, guys. Calm down, guys. We've seen this before.
The court decision is not the end of the battle.
Exactly. And it's not even directly a 2A related case. I really don't want to sensationalize things because I try to be a realist. The ATF is the bane of our existence, right? Many a gun owner. If we have gun-related problems in our day-to-day lives, the odds are pretty good that the ATF is responsible for them. Don't like the ATF as it is. The simple fact of the matter, however, is that the ATF historically doesn't claim Chevron in their arguments.
No, they very rarely rely on Chevron. They don't. They
go to court and they argue that, the things that they're saying, whatever they are just ordinary legal arguments.
Yeah.
And they're not going to court and saying, well, Chevron deference says that you have to defer to us. They're not doing that, possibly because they know it was a shaky, legal doctrine to begin with. But Chevron deference is not going to directly affect those kinds of decisions and those kinds of cases.
Yes, and it does not mean that a judge can't still rule in the administrative state's favor.
Exactly.
It just means that they're not legally required to defer that.
That's right. It's a shifting of the balance. It's not an earthquake. The impact that this decision will have on gun policy to me is one of nuance more than some earth-shattering upheaval, right? In overturning Chevron, the way that I see it, the Supreme Court is sending a signal to lower courts that the way that they review cases should favor a more, traditional balls and strikes approach. Like we were talking about before, that's the judge's job is to call those balls and strikes. When the ATF, for example, comes into a courtroom and says, well, even though we're not claiming Chevron defense here, we're the experts and you should listen to us anyway. The courts are hopefully getting the signal that they should be more focused on applying the law as it was written and applying it consistently. Hopefully just kind of, steering it back towards the middle, in my opinion. This decision is not a magic bullet. I think it's a step in the right direction of reducing administrative overreach. And back to our very favorite Justice Ketanji Brown Jackson and her dissent in Corner Post, the one that we talked about up above. Her quote, by the way, she had this to say: the tsunami of lawsuits against the agencies that the court's holding in this case and the case that overturned the Chevron doctrine have authorized has the potential to devastate the functioning of the federal government.
Yeah, they're really
fantastic.
They're really being hamstrung here.
I say that's a great thing. So yeah, if she's unhappy, then
it goes back
then
to
I'm probably happy. Good ruling. It's not going to blow up any current or upcoming ATF rulings or anything like that, but it's a good ruling overall. Just for liberty, it's a good thing.
The past Supreme Court session has, in my opinion, definitively returned some of the power to the people. Where it should be.
And with Cargill, and yeah, absolutely.
But very, very happy to see a core group of justices say, hey, the government doesn't have rights. It has authorities, and those authorities are granted by the people, and the power resides with the people.
So here we are rolling into July.
Beginning of July.
And that means drill of the month.
Yep. So the last couple months worked on a couple things that were a little bit outside of the norm. I looked at the effective range of my snub-nose revolver. We looked at the efficacy of different rounds for shotgun. How to evaluate defensive shotgun loadings. If you believe in the gospel of the gauge, you're part of the Legion of Boom or whatever the current phrase is. It's worth checking out. Moving into July, so towards the end of the year, I kind of already have the drills that I want to do all laid out.
Okay.
But for July, I'm going to one that I've done before, and it's the dot torture drill.
Oh, yeah.
I really, really like this one. It's nice and easy for July, for hot weather. You can do this on an indoor range. You can do this on an outdoor range. You don't need crazy equipment. It is a printable target that you can print on regular old computer paper. But it's a series of 10 circles on a piece of paper. If you look up torture target, you'll find it. But each circle has how that target is supposed to be shot.
Yep.
So like circle 1 is just 5 shots, slow fire, accurate. There's no time limit. Dot 2 would be draw and fire 1 shot and then repeat that 5 times. If you can't work from a holster on your range, just low ready.
Yeah.
Totally fine.
Work within your own constraints.
Again, this isn't timed. For dots 3 and 4, it's like draw, put 1 round on 3, 1 round on 4, repeat it 4 times. So it's those sorts of things. You start out, if you've never done it before, start out at 3 yards. Start nice and close, work through the drill. If you clean it, if you hit all of your targets, all the rounds are good.
Back it up.
Bump that target back out to 5 yards. If you really want more of a challenge, you can bump it out to 7, bump it out to 10. Do whatever you want. But it's a really great exercise that works on a lot of different skills, particularly in the marksmanship. There's even stuff where you got to do rounds with just your strong hand, rounds with just your weak hand.
And things start getting challenging.
It gets rather challenging, and it works a lot of different skills. So, yeah, by the time you're done, you're drawing, firing 1 round on 1 dot, reloading, and putting another round on another dot. So it's a drill that works a lot of skills, but very easy target-wise, not terrible on the round count. Something Excellent. To do in July. Again, nice and easy.
Dot torture.
And then moving into the rest of the year, we'll have all the other drills laid out. The year's going to end with a bunch of graded shooting tests that I'm actually going to do.
Oh, there we go. Right on. Little taste of the future here. Right as you get into hunting season, you're going to have to start telling you.
Well, these are all surrounding handguns. So it's certainly pistol oriented. But yeah, we're going to do some known shooting tests. And see how I score against the masses.
See how you do. Right on.
That's it for today. Thanks for listening in. Be sure to subscribe to the Goal Podcast and check us out on Facebook at facebook.com/Goal Podcast MA, on YouTube at The Goal Podcast, or on Twitter at Goal Update.
To join Goal, visit goal.org and click the join button at the top of the homepage.
If you have a topic you think we should cover, if there's something going on in your club or town, or if you have a question for the mailbag, shoot us an email at goalpodcast@goal.org.
The Goal Podcast is a production of Gun Owners Action League of Massachusetts. The views and opinions expressed are those of the host and guests and do not necessarily reflect those of Goal, its staff, or affiliates.